But let's take you through the very major timelines as we do know it in this case, and this how this has played out over the period. Dennis Puaberi, Wadam Esquires, my colleagues joining us here for this. He's been following this quite closely, researching it with the political desk and legal desk as well. Dennis, good to have you. Now, first off, let's do a quick backtrack with the specific timelines to this particular case and also where we are now at the moment. How did all of this start?
Well, so from what we have gathered so far, we can now say with authority that the presidency received petitions, 3 of them, 2 somewhere in February this year and 1 in March. And those petitions were seeking the removal of the Chief Justice. The first time we got to hear of these were in a statement that was issued by the presidency, by the Minister of State in charge of government communications on the 25th of March 2025, to the effect that these petitions, which we later learned were submitted in February and March, were forwarded to the Council of State for a consultation process to begin in accordance with the constitutional provisions that allow for this to happen. However, this was met with some pushback, and we saw that by way of the filing of some lawsuits 2 days after, that's 27th of March 2025. And these suits were to the effect that the Chief Justice ought to have given notice of these petitions and also an opportunity to respond to them before that consultation process between the President and the Council of State could progress. That is because this is not just a mere consultation. It is also this forum that will also determine whether or not a case has been made against the Chief Justice, for which a committee will be set up to investigate same, what is popularly called the Prima facie case. So in that regard, the people who were of the view that the President, having failed to give the Chief Justice notice of these petitions and also giving her the opportunity to respond to same, had violated some constitutional provisions for which they want the Supreme Court to declare that action unconstitutional. That was the crux of 2 matters that has been put before the Supreme Court. One of them actually sought to restrain the President from progressing on that tangent until a determination was made. So there was an injunction application that was also filed, subsequent to the writ of summons that were also filed at the Supreme Court. Now, on that same day, the Chief Justice later in the evening writes officially to also seek that she be notified of the petitions and, of course, giving copies and also be given 7 days to respond. This was on the 27th of March 2025. We would later learn that on this same day that Chief Justice was writing to seek to get the petitions and also to respond, was also the same day the President, according to him, had also sought the view of the Council of State as to whether the Chief Justice should be given the opportunity and if she should be given 10 days to respond to it. According to information from the presidency, it was the same day that the presidency got feedback from the Council of State, which had given the green light for the presidency to give the Chief Justice that opportunity.
Right.
So accordingly, the following day, which is 28th, the presidency writes to the Chief Justice, if giving her the petitions and also giving her 10 days. Mind you, she had requested for 7 days.
Yes.
But the presidency gave her 10 days to respond to these particular petitions. While at this, mind you, the cases are still pending, and these cases are in respect of the constitutionality or otherwise of the President proceeding to have the Council of State in a consultation without, at the time, was without notice to the Chief Justice or giving her the opportunity to respond. But now, as it stands now, even though the case is still pending, now the Chief Justice has been notified of the petition. She's been given the opportunity to respond. She has indeed, as we have gathered, responded to those petitions now, or she has made her input. So the consultation process also begin. But the question that now hangs or remains unanswered is whether or not these suits before the court are still relevant, for which they'll be heard on Wednesday, which is the 9th of April. That's your birthday, if I'm not mistaken. Yes, so
indeed.
Yes, we'll look out for that to see whether the Supreme Court will still sit on this matter and what the determination will be. But mind you, what is happening on the 9th is the matter of injunction, because like I did indicate, the plaintiffs in this particular matter said, let's put the process on hold. Let the Supreme Court make a determination before we get back to it. As to whether it will still be relevant or not, that will be for the courts to decide on Wednesday. So essentially, this is where we came from, and this is where we are. The outlook is that we are looking forward to Wednesday to see how things will play out.
Fantastic detail there. Dennis, appreciate you as always. And summarizing it all up for us to understand every step of the way how things have played out. Dennis Barbero with Esquire is my colleague here, and also on the political and legal desk as research also with us on this. But let's stay a bit further on this matter. And lawyer Martin Pebo is joining us on the telephone. It's private legal practitioner. Counsel, good evening. Thank you so much for joining us here on Hot Edition.
You're welcome, Mr. Ocansey.
Perfect. Now, so after this news of the Chief Justice submitting her response to the president following these 3 petitions seeking her removal, what next after today?
Yeah, so it means that now the president would be able to go into the matter, that's to determine if the allegations are serious enough and there is a bit of evidence, until a bit, so that's to say that it doesn't have to be all the evidence at this stage, because remember it is a paper, so you can't, there is a limit to how much evidence you can put into writing. Some of it you have to bring physically, pictures, audio, video, etc. Right? So at this stage, the president is supposed to look at the petition, look at the answer, that's the Chief Justice response, then seek the advice of the Council of State and come to a determination. But usually when we say prima facie, we should understand that it's a complex way to explain, but speaking it simply, that's why I said a bit of the evidence, but it shouldn't be so low that anybody can just make any allegation and it will pass through. But what also should be clear is that the petition should not, it's not possible for it to prove the case 100%. You see, so let's say, if in the petition, maybe the petitioner is alleging, let's say the petitioner is alleging that he saw Mr. Ocansey is CJ, and the petition is against Mr. Ocansey. Then he said that he saw Mr. Ocansey and Dennis Puabiri having tete-a-tete right after a case in which Dennis Puabiri is plaintiff and let's say Beatrice is defendant in the Supreme Court. I may leave out appellant to those things, but let's just say that Dennis Puabiri and Beatrice are parties in the case before the Supreme Court, and Ocansey is Chief Justice. And afterwards, saw Dennis Puabiri and Chief Justice having dinner and so many other things. He has eyewitnesses, etc. At the prima facie determination case, you can't ordinarily, you would say he should bring all his witnesses to come and do prima facie. No. But he says he will present so and so witnesses, etc. It means that it will be at the tribunal stage, all right? So it's such an allegation would most likely cross, okay, because it's alleging serious matters of ex-party communications and things about impropriety. So the point I was making is that you can't put the evidence, the witnesses. You've stated that you call them at the appropriate stage. So the prima facie determination, your case cannot be thrown out because there is no forum for you to bring the witnesses to the prima facie. If you are asked to bring witnesses to the prima facie stage, then it's like that will be a full hearing even before we get to the proper hearing. And so I'm just making the point that prima facie is a complex word, it's very varied. The meaning will vary from one example to the other. So generally, the way to look at it is that the allegations look serious, the person looks serious to prove them, generally, and they are within the constitutional limits, it will pass. Then when it gets to the committee stage, that the 2 justices of the Supreme Court and 3 lay people, that they are not lawyers, they are not MPs, they are not ministers, those 3 people, then they will now sit down and go into the case. Then witnesses will be called. They, as judges of the case, are also allowed to ask questions as they wish, because it's an inquiry. It's not limited to the court system where it's just adversarial. Yeah. This one is an inquiry, so they can ask as many questions to try to investigate the matter as much as possible. So that's where we'll go to if the petition and the allegations look serious enough. But if they don't look serious enough, and the Chief Justice's answers answer everything, clear all the doubts, then the petitions will be dismissed.
See, that's some good detail and basic explanation, at least for our listeners to follow every step of the way. So essentially, does a submission now lead to, or possibly lead to, the determination whether a committee will be established to investigate the allegations against the Chief Justice?
Absolutely. So it's at the end of it. If the president makes a determination with the advice of the Council of State that the case is serious enough, Prima facie has been met, then that's when the committee will be set up. But also by the president with the advice of the Council of State. But if he makes a determination that, the allegations are just wild allegations, they are not within the law and they are frivolous, etc., then he will dismiss it. And so that will be the end of the process, like what President Kufuor did when Professor Kweku Asare presented a petition against the Chief Justice.
Now, the other question that Dennis was asking, and it's been on the minds of many, is what happens to the court suit. In fact, the suit in court filed by the Old Tafo MP, that's Vincent Assefuwa, challenging the legality of the president initiating the removal of the Chief Justice, and then also one other Ghanaian, Ebenezer Owusu, also asking for an injunction on this entire process, because at the time the Chief Justice had not been contacted. Now the Chief Justice has been contacted. She's giving her response. Does that render these two suits mute that will be heard on Wednesday?
No, it doesn't render them mute, but it's also the muteness doesn't also come in because, okay, let's put it this way, let me rephrase. It doesn't render the suits mute. The court can go on and determine. But the Supreme Court is very clear that they don't likely injunct a public officer. So remember the e-levy matter, the suit was pending before the Supreme Court, and GRA went ahead. Remember the e-levy matter? Yes, the suit was pending in the Supreme Court, and the GRA went ahead with the implementation because it was clear to us that we said, hey, no. If you injunct the GRA, the GRA, etc., the economy will collapse. We needed all the money from the e-levy to create jobs. So you see all the things that were promised, that there will be millions of jobs to be created from the e-levy, all the rosy things that were said about the e-levy, because we all needed that to happen. It was clear that a lawsuit to stop this will cause too much trouble. That's just one example. There are many other ones. So because of this, that when it comes to a public officer, some, not everyone, there are a certain class generally that if you stop them, the public will suffer too much. There will be irreparable harm. Generally, the Supreme Court doesn't stop them, so they continue with their actions even when the matter is pending. So more or less, that's the court makes an exception. Okay, that's why they say to every rule there's an exception. To every rule that when there's a case in court, stop, so that the court will finish deliberating before you continue. There's an exception. And that's one of them, that the president has a constitutional duty to perform at this time, that the process should go on. So you don't likely injunct. They don't. You know, as I said, it varies from case to case. Another case will come, though it's a constitutional duty, when the majority of Ghanaians get up and voice their anger, disgust, and sense of this and feeling that it's injustice, that public officer will stop. So a lot of these things is the public, the participation of the public, the posture of the citizens also helps. When many people are very angry about it and they think the president should stop, he will stop. But where there isn't enough behind, like a critical mass of people asking the president to stop, generally it will continue unless he himself just says, listen, I'm just stopping. Sometimes they do. You remember when Professor Kweku Asare sued that he didn't want the constitutional review process to go on. You know, after they were done and they said, while the case was pending, while they were trying to do the constitutional review, and then he went to court. That's the implementation stage. So he went to court. So President Mahama had to stop the implementation the committee didn't have to wait. They had to wait for the case to be dealt with. And by the time they were done, there wasn't much time, and then the president lost elections, etc. So sometimes the president can stop, but other times, depending on the circumstances, they will continue. So we take it on a case-by-case basis.
Thank you for this detail, and we'll see how Wednesday plays out. And after getting to know today that the Chief Justice has responded to these petitions, we'll see the next stage that this whole process will take. I thank you so much, Counsel, for your time.
You're welcome.
Martin Pebo is privately